adjourned hearing to January 13th. And then they've made a subsequent order for a suspension of preparations towards organizing the KPANDAI RERUN. Remember, that's the order of the High Court. The Supreme Court is hearing an application that's challenging the jurisdiction of the High Court to hear that matter. So let's start first and get some understanding of exactly what transpired in court yesterday. Has anybody won? In Ghana, when you go to court, they will ask you, did you win the court case or you have lost it? Anyway, EUGENE Kwame AWITY is member of the legal team of the NDC parliamentary candidate for KPANDAI. Thank you very much for your time. Good morning to you.
Good morning, Senator.
I hope you're well.
Thank you for having me too. I'm doing well. And good morning to your cherished listeners.
First, explain to us what you were in the Supreme Court to do yesterday.
Okay, so we were not in the Supreme Court. The applicant, Honorable Matthew Nyandam, through his lawyers, have filed an application for judicial review in the nature of a certiorari. That application was listed to be heard yesterday, the 16th of December 2025. But as you may have heard, the NDC parliamentary candidate, Honorable Daniel Salawakpao, whose rights will be affected by the determination of this matter, had not been served at the time the matter came up for hearing. And so the court, they took an application for substance service, which the applicant had brought, and same was granted. And so when Honorable Daniel Salawakpao is served by the means of substitution granted by the court, he will have to file an affidavit in opposition and also indicate to the court why this remedy of certiorari ought not to be granted. So basically, that is what happened. And we have also learned that the court made further orders directing the Electoral Commission to suspend all processes leading to the rerun of the elections in KPANDAI until the determination of the matter before them. So basically, that is what happened yesterday at the Supreme Court.
You were not in court at all yesterday?
No, I was not in court. Like I said, Honorable Daniel Salawakpao has not been served.
So his lawyers, he had no representation himself. He was not in court.
He has not been served, so he was not in court. But we have our means of finding out what happened in court. We can always apply to be served with processes. But until he's served, he would direct his lawyers. And you know that we were lawyers for Honorable Daniel Salawakpao in the trial high court in Tamale. Now, it remains to be seen. He may appoint different persons to represent him in this matter. But until such time when he's served, and then he will now file his affidavit in opposition. So the rule indicates that he must be served personally. And if they are unable to serve him personally, then the applicant can bring an application for substance service, which was done yesterday.
But, okay, so you found out what has transpired in court, but you said you have been subsequently served. Has he been served?
No, I'm saying that the application for service on him has been granted by means of substitution. So my understanding is that he's supposed to be served by his WhatsApp number, posting on the notice board, I think in Tamale also, and then one other means. I'm yet to actually read the orders of the court, but we have a fair understanding of what transpired yesterday.
That's quite interesting because we've been discussing this matter for some time now. Exactly. At least we in the media are aware that something had been filed in the Supreme Court. It's surprising that the other party on the other party does not have service of the application.
Yes, I mean, the rule says that in order for a matter to be determined, so that we don't breach natural justice principles, the person must be served personally with the process. You understand? So, in the absence of personal service, the court will not proceed to determine matters before it, especially when those matters affect the rights of the respondent or other persons involved. Yes.
And then, and I guess you also have heard of the Supreme Court's further order that suspends processes to organize the rerun on 30th December. How do you respond to that?
Yes, we have heard about that one too, and I mean it is welcome news. It was to be expected. I mean because for service to be granted, I mean by substitution, the court grants a certain period of time. In this particular instance, my understanding that it is 7 days. After the 7 days, the applicant has a certain period of time also to file a response. So what it means is that by aggregation, by the time the matter comes up for hearing, just maybe the elections might have gone on. You understand? Because if the electoral commission proceeds to hear the electoral commission proceeds to run the elections before the matter comes up before the Supreme Court, and then it means that they are whatever ruling they are going to give will be, we use the term nugatory. You understand? It will be taking a decision after the act has occurred. And so, I mean, it made a lot of sense for the Supreme Court to stay proceedings. Because, of course, when the rerun comes up, I mean, several other persons may also decide to contest. You understand? It doesn't necessarily mean that it's just Honorable Martin and than in Sarawak. And so, to the extent that the rights of persons will be affected by the decision, the court rightly ruled suspending the rerun till the matter was determined before them.
Well, I guess, but the key thing that has been raised over and over again is that this whole matter is based on the fact that they are saying you filed the application out of time. Did you? The petition out of time. Did you?
Our case is that we did not file the petition out of time. So we filed an earlier petition, let me say, and before the trial court, the applicant, by his lawyers, filed a process and exhibited a gazette dated 6 January 2025. I mean, we relied on that gazette filed per supplementary affidavit and discontinued the initial process and filed another one. You understand? So far as we are concerned, we filed within time, within 21 days. It's stipulated by the rules for an election petition to be brought. Now, without going to the merits of the matter, because that is what's essentially before the Supreme Court to determine, I'll just hold my horses here. It is our case that we filed in time, and we are saying that the 6 January 2025 Gazette was the basis for which we discontinued our earlier petition and filed another one, 25th January 2025. So the matters, now that matters have come before the Apex Court, let us just hold our horses and see how it determines. Because you see, for an application for certiorari to be granted to quash the decision of the High Court, a number of grounds ought to be satisfied. One, that maybe there's a breach of natural justice principles, there's a lack of jurisdiction, or that the court acted in excess of its jurisdiction, or that there's a patent or fundamental error on the record. But in limited instances too, the court can also intervene in the interest of justice. It's what we call the Westbury principles. Now, this remedy of certiorari is a discretionary one. What it means is that the court reserves a right to consider some other factors for which reason they will rule that you are not entitled to the grant of the certiorari. You understand? It's not an open and shut matter. That once you establish these grounds, that is, the court grants it. Sometimes the court relies on some other considerations. And so let's just hold our horses and see what comes out of the matter. I don't want to prejudice the matter before the court. But in summation, this is the explanation about the law of certiorari.
In the meantime, I guess you're waiting for the ruling on the stay of execution?
That is so.
Okay. What has a date been given when this will be delivered?
So it was scheduled to be given on the 18th of December 2025. Now, you see, the effect of the Supreme Court's order I think will be operating on the mind of the trial judge. And so, not to prejudice what he will say, but essentially that is what the applicant wants. And if the Supreme Court has granted them in this particular matter, we can only speculate what ruling the High Court judge will give. But yes, that ruling is coming up on the 18th of December 2025.
And that is tomorrow. And we also understand, have you or your client, if he still decides to retain you, has he brought to your attention any maybe an appeal being filed, duly served on him?
Yes, we are aware that the applicant has filed an appeal. In fact, the applicant has filed 2 notices of appeal before the Court of Appeal. So, yes, we are aware. He has brought that to our attention.
Duly served, Mr.
The first
Wakpa?
one was served on him on the 24th of November 2025. The same day, the High Court delivered its judgment. Now, subsequently, he's filed another one dated 1st December 2025.
And both of those are existing. He hasn't withdrawn any.
So yes, both of them. I can't speak to the matters and what the applicant intends to do.
Okay.
Yes, but he filed 2. He has filed 2 notices of appeal. I want to believe that maybe he may want to withdraw one, or I was not in court the last time in Tamale, so I don't want to speculate about the matter. But yes, he filed 2 notices of appeal, one on the 24th of November 2025, and another on the 1st of December 2025.
I see. Well, there's quite a lot to look forward to. Thank you. But thank you very much for speaking to us.
Thank you very much for having me. Have a wonderful day.
You too. EUGENE AWITY is member of the legal team for NDC's 2024 KPANDAI parliamentary candidate, Mr. Daniel Nsala. And of course, what we understand was that, so now we have a bit more. So they went to court. That is Matthew Nyindam and his lawyers. They were informed that Mr. Daniel Nsala has not been served yet. So Mr. Nsala was not in court, neither was his lawyers. So those 2 things, meaning they now have to find a way of serving him. And that's where the matter of substituted service came in. And we'll be trying to get some education. And he also explains to us that he's not supposed, they understand what went on in court. And if Mr. Nsala decides to retain them as lawyers, they can continue and do the work. Of course, a few things have to happen. That's why the Supreme Court decided that push it forward